On March 11, 2026, in Thurston County District Court in Tumwater, Washington, defendant Mr. Rutherford faced sentencing on 2 criminal charges stemming from a DUI incident. Count 1, driving under the influence, and Count 2, hit and run. The case presented the court with difficult questions about alternative sentencing options when a defendant raises health concerns, and how judges balance mandatory minimum penalties against individual circumstances. What unfolded reveals critical aspects of Washington's sentencing framework for DUI offenses and the limited discretion courts have when health-based alternatives are sought.
Speaking on behalf of others as well, and that's great. The public participation is part of how the Tumwater City Council and other leaders in Tumwater make their decisions that affect everybody. So your participation in that is great. It's noble, and it certainly counts in your favor. I do have to say that if I'm considering the possibility of alternative forms of incarceration based on physical or mental well-being, those are the physical or mental well-being of Mr. Rutherford, not his spouse, who may have her own physical issues, but those can't be considered in finding a basis for the alternative to incarceration under the sentencing statute. So I'm going to focus on you, Mr. Rutherford, and I know that you're not what I guess it's fair to say, based on what you've said and what Ms. Kameri said, that you're not in great health right now. You've had some health challenges. It's difficult to say exactly what they are, how extensive they are, or how those health challenges relate to incarceration or relate to serving time on EHM, because that evidence hasn't been put before me. So I don't think, as the evidence stands now, that I have a basis to grant an alternative form of incarceration to the mandatory minimum penalties. So because I can't make that finding of the substantial risk to physical or mental well-being that the statute contemplates. So I don't make that finding. So what I'm going to do here, in the interest of resolving this case, getting you to the point where you can move on from this and deal with your remaining case, which I think is, in your interest to do. I don't want to place you on 60 months of probation as which was part of the city's recommendation. I don't think that's the appropriate course to take here. So I'm going to give you a sentence. Once you complete the custodial portion of this sentence, then the case is going to be closed without any further probation. So for count 1, driving under the influence, I will impose 364 days and suspend 274 days. That leaves 90 days to serve, and per the statute, that is going to be served as 30 days of total confinement and 60 days of electronic home monitoring. I'm making the further notation here that once that custodial time is completed, this case is to be closed with no probation. Count 2, hit and run, your sentence is 90 days, no days suspended. The time will run concurrently. The custodial part of this sentence has to start being served by April 7th. I think that gives you around a month to make the arrangements that you need in order to do that.
The judge rejected Mr. Rutherford's request for alternative sentencing based on health concerns, finding insufficient evidence to support a substantial risk to physical or mental well-being under Washington law. The court then crafted a hybrid sentence combining jail time with electronic home monitoring, while explicitly rejecting the city's recommendation for 60 months of probation. Under Revised Code of Washington Section 9.94A.660, commonly known as the First-Time Offender Waiver Statute, and more specifically RCW 94A5301B, courts may impose alternative sentences only when the defendant demonstrates by clear and convincing evidence that standard incarceration would create a substantial risk to their physical or mental well-being. The Washington Supreme Court in State v. Shove, 1992, established that this statutory language requires more than generalized health concerns. It demands specific, documented medical evidence showing a causal connection between the defendant's condition and the proposed incarceration method. Additionally, RCW 46161555 mandates minimum penalties for DUI offenses, including at least 1 day of jail time for first offenses, which constrains judicial discretion regardless of mitigating circumstances. Here, the judge applied this legal framework precisely. Despite acknowledging Mr. Rutherford's community involvement and apparent health difficulties, the court found no evidentiary basis to conclude that 30 days of confinement plus 60 days of electronic home monitoring would pose a substantial risk to his well-being. The judge explicitly noted that evidence of health challenges hasn't been put before me, demonstrating that mere assertions of poor health, without medical documentation or expert testimony linking specific conditions to specific incarceration risks, cannot satisfy the statutory standard. The court also correctly excluded consideration of the spouse's health, as RCW 94A.660 limits the inquiry strictly to the defendant's own physical or mental well-being. This exchange illustrates a critical reality for defendants seeking sentence alternatives. Statutory exceptions to mandatory penalties are narrowly construed and factually demanding. Courts cannot simply substitute compassion for evidence, and defendants who fail to present concrete medical documentation risk receiving standard sentences despite genuine hardships. The ruling also shows how sentencing judges retain significant discretion in structuring punishment within statutory bounds. Here, eliminating probation entirely despite the prosecution's request, while remaining constrained by mandatory minimum requirements that reflect legislative policy choices about DUI severity.
I'm going to waive financial obligations because it's been explained to me that you're unable to pay them, and you're also represented by the public defender, so it's certainly appropriate that you not be placed under a requirement to pay any financial obligations. The only reason that there will be any suspended time or any conditions imposed is to ensure that there's compliance with the sentence. So that means that I'm setting a probation condition of no driving without a license and insurance, no criminal law violations, no bars or taverns, no alcohol, marijuana, or non-prescribed drugs, and no breath test refusal. But those conditions are only in place until the custodial part of the sentence is served. So what I'm saying there, Mr. Rutherford, what I mean by that is if you were to go out in the community and drive with a suspended license, or commit a criminal offense, or go to a bar or tavern, that would violate the suspended part of your sentence, and you could get the other 274 days of custody. But once you've completed serving those 90 days altogether, the case is just simply.
Thank you, Your Honor.
Okay. Now, I hope you can move on from here and continue on being a stand-up member of the community.
I will, Your Honor.
Thank you, Mr. Rutherford, and good luck to you, sir.
Thank you, Your Honor.
Okay, and Ms. Kamari, did you want to call any other case?
Time, Your Honor.
Okay, Mr.
The judge imposed suspended sentence conditions that function as a safety valve during the custodial period, explaining that any violation during this time could trigger the full 364-day sentence. The court waived all financial obligations based on indigency, then formally concluded the hearing. Under RCW 94A.702, Washington courts must consider a defendant's ability to pay when imposing legal financial obligations, and State v. Blazina, 2015, held that courts cannot impose costs that impose manifest hardship on indigent defendants. The suspended sentence structure here operates under RCW 9.94A.633, which allows courts to impose conditions during a period of confinement that, if violated, permit revocation and imposition of the original suspended term. This execution-suspended framework, rooted in the historical common law concept of reprieve, serves dual purposes. It provides incentive for compliance while preserving judicial authority to enforce the full statutory penalty if the defendant reoffends or violates conditions during the active supervision period. The judge crafted what amounts to a mini probation lasting only through the 90-day custodial period, substantially shorter than the city's requested 60 months, while using the suspended 274 days as leverage to ensure compliance during that window. The specific conditions, no bars, no alcohol, no driving without license, directly target the circumstances of Mr. Rutherford's DUI offense, reflecting the individualized condition setting authorized by RCW 94A.633(1). The waiver of financial obligations followed Blazina's mandate, with public defender representation establishing indigency. Imposing costs would have been legally impermissible and practically unenforceable. This sentencing structure demonstrates how skilled judges navigate between mandatory minimum constraints and individualized justice. By front-loading all custodial time and eliminating post-confinement supervision, the court minimized long-term state intrusion into Mr. Rutherford's life while maintaining accountability through the suspended sentence mechanism. For defendants, this approach offers a clear path to finality. Complete 90 days with clean conduct, and the case closes permanently. For viewers, it reveals how sentencing hearings involve complex calculations of risk, resources, and rehabilitation, calculations that occur within statutory frameworks that limit but do not eliminate judicial creativity. Mr. Rutherford was sentenced to 364 days with 274 days suspended for DUI, requiring 30 days of total confinement and 60 days of electronic home monitoring, plus 90 days concurrent for hit and run. All financial obligations were waived due to indigency. The custodial sentence must begin by April 7, 2026, after which the case will close with no probation, provided no violations occurred during the 90-day period, which would trigger the full 274-day suspended term. This sentencing hearing illuminates a fundamental tension in American criminal law: the pull between standardized penalties designed to ensure consistent punishment and individualized assessments that account for human variation. Washington's DUI sentencing scheme, like those in most states, reflects legislative judgment that drunk driving poses severe societal risks, warranting mandatory incarceration. Yet the same legislature created narrow escape valves for exceptional circumstances, valves that courts must apply cautiously to avoid undermining the statutory scheme. The judge's handling of this case exemplifies proper judicial methodology, acknowledging sympathy for the defendant's situation while insisting on evidentiary support for any deviation from standard penalties. This approach preserves both the rule of law and the possibility of mercy, recognizing that statutes create floors for punishment but need not prevent judges from crafting sentences that minimize unnecessary hardship within those constraints. For defendants and their advocates, the lesson is clear: alternative sentencing requires preparation, documentation, and proof, not merely pleas for compassion. And for citizens observing the system, the hearing demonstrates that even in cases involving serious charges, careful judicial attention to individual circumstances remains a vital component of justice. If you found this analysis valuable, subscribe for more educational breakdowns of real courtroom proceedings. Share this video with anyone interested in understanding how criminal sentencing actually works, not as portrayed in television dramas, but in the measured, precedent-bound reality of American courtrooms. Comment below with questions about Washington sentencing law or suggestions for future cases to examine.